Good evening and welcome to Slam the Gavel, the show that tells it all regarding family court, other court issues, as well as CPS. I am your host, Marianne Petrie. You can find me, my books and blogs on dismantlingfamilycourtcorruption.com. I have two brand new guests on. I have Katherine Moore, Juris Doctorate, master's degree, and a certified fraud examiner, as well as Carol Moore. And she's going to talk about being in 12 years in district court, 14 months in the middle district federal court. And she has a brief in the federal circuit appeals, Fourth Circuit. I hope I'm saying that right. But we're going to talk about that. We're going to talk about 42 USC 1983 and the stats and extrinsic fraud and how Katherine has built data and the hallmarks of cases that they are noticing a trend in. I totally welcome you, Katherine Moore and Carol Moore, to the podcast.
Thank you so much for having us.
Thanks.
So you just filed an important document. Tell me more about that.
Yes. So I'm part of a group of ladies from North Carolina. We are all engaged in what has been relatively protracted family court cases. And our concern is some of the patterns that we've seen across all of our cases, even though we're in different districts. And it really began for me with Joan Meier's statistics. I will say that I have seen them really ring true as it pertains to my case. I'm literally the quintessential statistic. Absolutely everything that she identifies in her data is and has happened in my case. And so it really made me more interested in what exactly does the study say? How does this pertain to other mothers and fathers, really?
Mm-hmm.
And what other information is there out there with regards to how family court is proceeding and the dramas that we're seeing? One of the things that I noted in Joan's statistics, and she and I have had an opportunity to speak, is a lot of people like to reference that 76% of abuse cases that get dismissed. And she and I discussed the fact that that it's the 28% of quote unquote credited, in her case it's mothers, but what you call credited mothers who have some success in court and aren't summarily dismissed. But that 76% that is dismissed isn't recognizing some of the patterns of what we call extrinsic fraud that is intended to specifically discredit accounts of abuse. And it happened in my case and in all of the other cases with which I'm personally aware. If you walk into a courtroom like I did with an actual recording of someone discussing their assault on you, and then a medical record to accompany that, and then to have that dismissed and not admitted. It was initially admitted. We took a recess so that the judge and opposing counsel could listen to the 1 and 5 minute long recording to take advisement of the medical record. And then we played about 3 seconds of the recording and it was then unadmitted. So now I'm instantly an uncredited statistic. I am the 76%, but I walked in with a recording of the actual discussion of the result of the assault. So I'm finding that those stories are actually ubiquitous. What's really happening is the evidence is not being entered. Mm-hmm. It's being suppressed. Mm-hmm. It's being disregarded. These moms and dads are smart. They know that it's difficult to walk into any court case with just he said, she said. So almost no one that I've met has just made a verbal accusation. People are coming in with medical records and other kinds of data, and it's being discredited. And so that's where your 76% is coming in. And that is called extrinsic fraud. And it happens in courts apparently everywhere. And the question is, why are we seeing that? And what other kinds of misconduct and extrinsic fraud are we seeing? And we are noticing certain patterns and certain data points really evidence and foreshadow how your case is going to go. Mm-hmm. I have had change of venue requests. My change of venue requests were denied. No one lived or worked in the county where my litigation was instituted. I'm finding that in most of the cases of the mothers that I've spoken with and with some of the fathers, that's the case. And it's an interesting statistic because we all know that in every facet of the government, everyone has huge caseloads and everyone is really overworked. I mean, there are 400 million Americans. So everyone in whatever realm that they work is really busy. And it's always interesting to me that someone would care that you don't, that they preside over your case specifically. Of course, venue change and venue motions are typically made at the beginning, at the outset of litigation. So why does anybody care in the beginning that they retain your case? And I think we can all make deductions and kind of analyze why we think that may be happening. Typically that's paired with plaintiffs or with parties rather, who have multiple attorneys. And we're finding, I would say almost 100% of the mothers with whom I've dealt with in the last several months have had at least two. And if we really think about litigation, that doesn't happen often. Oh, I'm glad to know. I didn't know that about you. At least two. Let's think about how cases really go, whether we watch them on TV or we know someone else is in litigation. Most parties have one and they see this through to the end. But in family court, it's not unlikely. It's not uncommon to see 2, 3, 4, 5. Why is that happening? We have ideas, but that's what the data is going to tell us. Why is that happening? Well, we know in some instances, we're draining mothers financially. It's a tactic. It's debt coercion. It's financial abuse. In cases where the parties are married and there should be some element of equitable distribution, the mother is supposed, or the father, I mean, we know this is happening in different arenas to the dads as well. So we know this is a tactic. We're financially abusing, we're implementing essentially debt coercion tactics against the opposing party to drain their resources, to make litigation difficult for purposes of prevailing. That's what the data is showing. And it is a concerning tactic in an arena where it isn't just the opposing party, but the implications are, of course, on children and other people. And so there are points that we are going to start reviewing. In addition, essentially, Joan and the George Washington University data, the DV Elite project definitely has provided the foundation for the information that I'm going to continue to gather, with the hopes that we'll have some additional data to provide in terms of why are we seeing this massive amount of what people are categorizing as corruption and extrinsic fraud.
Not only does the tactics of financial abuse impact the ability of how the court unfolds, but it really determines child custody, because once the finances are looked at, then the next step is, how are the children going to be provided for, who receives the children, all of these other aspects of child custody comes into play. So the first step for the courts to come in and accurately identify the finances through first of all is to identify the finances, the assets, to then categorize, classify, and then distribute in an equitable way, because family court is to be equitable. Once that equity is decided, then the next step is, how do we problem solve and make a decision, is what is in the best interest of the child. And this is where it gets really, really gritty, because what, I think I can say this correctly, but what's happening is you see a lot of mothers that are finding that they are the parties that are finding themselves without finances, and then the children when the judge starts looking at the evidence, would say that the father has the finances to care for the child. And then all of a sudden, the children go to the father. And then the mother is left in a position of not being able to present her case and why she is important in the child's development, in the child's life. In the fact where there's mothers without the children that have been taken away, they can't even participate in the child's life. So it goes back down to that extrinsic fraud and identifying how the court is operating in a way that's beneficial to the family, but also what happens to the children. It's essential.
And one of the reasons that 4D, Title 4D, is a theory, a legal theory under which the 1983 is being brought, is because we know that it's being utilized in two different ways. One, it's being weaponized to some degree. We understand that in a lot of cases, opposing party, in anticipation of having to be held as essentially the obligor for payments for child support, is utilizing these tactics in advance so that they can essentially escape having to make child support payments. So essentially what's happening is that there are a number of people, if you get someone who's a relatively decent tactician or their attorney is, and they understand that at some point they'll be making child support payments. I've literally had someone say to me, I can pay $20,000 and get out of 18 years worth of what may be $200,000. So it's an actual, and it's an actual formulaic move. And so it's being weaponized in courts, but it can also be helpful. It can be helpful for those who are litigating, as in the case of the 1983, because Title 4D has provisions in there that requires the court to consider what is in the best interest of the child. Title 4D is explicit that any litigation that results in a child support order needs to be predicated on litigation where everyone had full access to litigation, meaning, and it wasn't fraudulent, meaning you can't suppress evidence and then enter an order for Title 4D that's considered valid, because it wouldn't be valid under the provisions of Title 4D. And that's what's happening. That's where the 1983 for the North Carolina mothers that are currently in court now, that's one of the basic fundamental tenets that we're asserting. Your child support orders are not valid. Some of your custody orders are not valid when they're in violation of the federal law that promulgates the rules that govern how the funds are administered and how the courts are supposed to deal with you. So the evidence suppression and the extrinsic fraud that we're seeing, we think undermine the rules that govern how the courts are supposed to be presiding. And we're seeing that in the data sets as well. Carol's case is a fabulous example of actual numbers and dollars and cents of when that can happen. And it really happened on its face. And I don't want to tell her story.
I'll give you a snapshot of what happened, which it's a perfect example of how equity is looked at in district court. And if you see that part, then you can connect the dots with the child custody. So just briefly, I won't go into the weeds on this, but briefly, I was in Orange County District Court for 12 years. I made 15 appearances in all. This was where I believed that the district court was going to resolve the issues. It was a belief, but that was not what happened. And in those 15 appearances, that's when I started figuring out what was really going on, because I would make the court appearances. And at that time, my ex-husband never showed up except for once. And he never had an attorney. I came in with evidence, third party, independent, forensic, financial evidence. And my evidence was not ruled on. And that was a real problem. I didn't understand it. It wasn't where I was making any kind of, or asserting any kind of subjective facts. It was hardcore forensics. And I was kicked out the whole time. And so at the end of my court appearances, and I explained the case as to what was going on, the judge filed a gatekeeper order against me and said I could not come back into court. I received that gatekeeper order in response to a change of venue. I'd gone to the Chief Justice and written a motion asking to be changed of venue. The Chief Justice handed it to my district judge, and he booted me out, saying that I was being frivolous. At that point, I had to make a decision about the next step, because I understood not only was my financial evidence and my facts being concealed, but it was even broader than that. It was the denial of my reality of what had taken place. And so being denied my evidence to go into the courtroom and present my evidence and rule on my evidence, which was specifically financial, my whole reality was thrown out the door, like I was objectified. So at that point, I made a decision to go pro se to federal court and ended up in Middle District and presented my case in Middle District on 1983. And I submitted my evidence there. I was in federal court for 14 months. And when you go into federal court as pro se, you're not given any special attention. You are in a federal system and you have to present your evidence without an attorney and present it in your best case. And I felt confident after 14 months that I was being taken seriously. I was dismissed in October. I'm immediately, and I was dismissed on Roker Feldman. And I immediately turned right around and submitted evidence to the Fourth Circuit. I wanted a review, because for me, I wanted the answers of legally why my evidence was not being considered. Why? Because I believed that my civil rights had been violated. What happens in district court, as we were talking about, one of the side effects of an extrinsic fraud is where one side's evidence is heard. So the narrative is based and is one-sided financially on one person's evidence, where in my case, my evidence was totally concealed. So that made the judgment fraudulent, because it was only one-sided. And that was the point. It was like, if you're going to go into a courtroom, there's always two sides to the conversation. And in my case, it was one-sided. Of course, I know now, today I know what happened to me, but it took forever to identify what was going on. But I know today what's going on. It was extrinsic fraud. And then now Fourth Circuit has my brief, and we will wait and see how they look at this and what their decisions are. And I'm very hopeful. So I'd like to say I'm very hopeful. The second thing I'd like to say is pro se people should never back down or be afraid of going into federal court. I don't think that's an option. I think going into federal court pro se, yep, it's a pretty gutsy thing to do, but it's not an option. Especially if you're starting to see the data,
yes,
that shows that there's something wrong.
And I'm going to speak to Carol. I'm just going to give her props for a minute, because I read her case and saw a lot of her data before I met her. And I was taken aback by this lady who had been in court for so many years, battling a large law firm, and just would not give up. And I think she speaks for a lot of people, and she is a great example for anyone who may be reticent to go into federal court alone. She's doing it alone. The access is there sometimes when it's not in your local state court. And so don't be afraid. That is certainly a message that we want to send out there to all the parents. Learn, go in there with the knowledge that you need to properly file. But make sure that you access the court in that way. And I'm going to speak again to the evidence, the issue with the evidence that we're all saying. Carol, as mentioned, had her evidence suppressed. She attempted on many occasions to have hers was a straightforward. She had forensic expert examiners look at the money and how the monetary transactions were proceeding. And you would think that if you can obtain that kind of evidence, that level of high quality evidence, really.
Third party independent.
That's right.
Total examination of the finances.
Right. Everyone thinks that. I think we all operate in a sphere of, okay, you go into court, you just need evidence. And when it is not, you're not allowed to admit it, you're not being allowed access and the opportunity to actually litigate. There's only one person in there fighting when you're not allowed to introduce something like a third party forensic examination. So that is ubiquitous. It's ubiquitous to every case that I have ever seen. It's universal. The party that is, having a problem in court has not been allowed to present their evidence. It happened to me. And so it is a significant access to justice. Another one of the theories that we have in our 1983 is VAWA, the VAWA implementation. It's a fabulous way for us. We felt like it was a fabulous way for us to attempt to access the system because your states are taking funding for VAWA. And VAWA does have, it has regulations regarding what's required to remain in compliance with this funding to obtain additional funding for the next year. And some of the tenets do require that you have victim-centered law enforcement, that you have trauma-informed courts that recognize when victims come into court that the proceedings should go in a certain way. And of course, it emphasizes the fact that everyone is to have access to justice and to the courts. And of course, you're not having access if you're not allowed to actually fully litigate.
No, not at all. And it seems like, and what I have heard from other parents on this podcast is their evidence was suppressed. The judge would not even look at it. And the clerks can withhold evidence and not even show it to the judge.
So that's another data point that we are studying. We did request leave to amend as a matter of right, because there may be additional defendants. But we recognize that a lot of the flow of the evidence has to flow through your clerks first. And we're seeing that in a lot of cases, two things are happening. The evidence before you even try to admit it into court isn't making it into the file. And everyone has had at some point difficulty accessing their file. And it's really difficult to argue when you don't know the full picture. And so you have to have access to that information. In North Carolina, the state of North Carolina implemented e-courts recently, and there have been significant bumps in the implementation of that and to the rollout of that. Because we have a mom who has not been able to access her file at all. And so how do you fight when you don't have all of the information? And so we really are hoping that one of the things that comes out of all of this, as we delve into the data, is that there are some large systemic changes. Because we know we're hopeful and we're optimistic, and we do believe that most people want to see families. We know that the reality of it is that they don't always stay together, but we hope that everybody has a fair opportunity to litigate in court, and that people are really considering the interest of the child. Don't make you know, the money and the way you, the tactical position that you have in court shouldn't be what's prevailing in terms of how the litigation goes. It really should ultimately be what is in the best interest of the kids that are at stake and the families that are at stake.
So I think what I'd like to say in conclusion of this, when you walk into Orange County District Court, the mission of the court is posted. And I took a picture of it because my belief was this is what was going to happen. And the mission of the court is that families would go in and resolve their problems equitably in a reasonable amount of time. So that was the belief that I walked into the courtroom with. But 15 appearances later, 12 years later, I found that the court, even though it's an adversarial system designed to find out the facts and the truth for equitable decisions, that's not what happened. Problems were not solved. In fact, I'm thinking of some mothers where their problems, that was the beginning of their problems, and they had to continue to fight in court, within the court, for some kind of solution, and it never happened. And in my case, although there are no children involved, there was not a solution. There was a gatekeeper order. That was the end of my experience, which landed me in federal. So obviously, we're not talking about the family's problem. We're talking about the family trying to resolve the problem inside of the district court, which seems just to make the problem bigger. So walking into family court is not for cowards. It's and the women I've met are heroes, and they go in, and the fathers too, and try to resolve the problems within a system that seems to be that doesn't seem to help. And hopefully the data will clarify some of these problems within the system to make it a little better in terms of how to resolve these family problems. And what, do you have anything to say on that?
Carol makes a poignant point about all of it. And the mission we know of all courts is to really adjudicate and to preside over cases that are intended to work out problems, you know, in a society in a neutral way. So we're hoping that with the data that we see, that we collect, we can identify some of the pressure points, what is happening, so that we can then have them addressed through legislation and through compliance and oversight.
Exactly.
And so that we can prevent this perpetuation of what we've been seeing for the last several decades in family court.
Yep, that's it.
And what do you think about, this will be my last question, what do you think about these attorneys that just call out false accusations on the mother or father, and the judge just runs with it? There's no stopping it. The other attorney can, you know, say, hey, I object, or not say anything, and it just spirals downward.
So and the data has shown that with the mothers, this is 100% of the cases, 100% of the cases that I've seen, there has been an accusation of mental health, mental instability for mothers. And my first response was, what an old trope. How is this not original, any more original than that? Secondly, when you start accusing every woman who walks into the court of being crazy or delusional or unstable, then you really take the power from it. No group has 100% of a characteristic. It is intended to impugn character, to discredit. So again, we talk about credit in the context of Joan Meier's definitions. It is intended to discredit the mother when she comes with accusations of abuse, because if that's what you do, if you're an abuser, you lie, you certainly don't admit to abusing, and you hope to discredit the mother. So it's a tactic that we've seen. This is another universal in the data points. Everyone has had someone call them crazy or emotional or unstable. And all of the mothers that I've met and with whom I've spoken and, really interviewed about some things, they're professionals, they're fabulous mothers. Here's how
Agreed.
arbitrary that data point or that tactic is. Several mothers have several children. In our case alone, we have mothers with 6 children. And the only child that had decreased custody or custody was switched was the child where an allegation of abuse was made. But the same courts in North Carolina thought, but with the other 5 children, you're a good mom. You have full custody. But for whatever reason, the opposing party said, okay, this is a reasonable tactic. I'm going to call the mother of my children crazy. And then that's part of, the whole package where you attempt to discredit the opposing party. But it is something that I think as the data will begin to really show, it'll elucidate the fact that it is, in its widespread usage, it loses its power. You just don't have any validity to something that you claim universally about everyone, and particularly in a context where it doesn't make sense.
Right.
Totally outdated. Totally outdated.
I agree. I'm so glad. Oh, go ahead. Were you going to say something?
No, I just appreciate the opportunity that the data can be out there now and people can make a decision on their own as to what this means. And that the statistic of dismissals is.
We think that will really,
change.
we think that'll change. We think that there'll be some update to the wonderful statistics that are coming out of George Washington. Like I said, we're going to expound upon that and add a few different elements into it now that we're seeing some of the patterns of the fraud and abuses that are happening across the courts, really nationwide.
Definitely. I totally am so glad you came on to share this with everyone, to give us some hope that there will be change.
Thank you for having us.
Thank you so much. Appreciate it.
I'll have you back on with any updates if you want to come back on.
We would love that. We would love that.
Hey, don't
I
jump.
got the end of the story.
Yes.
Oh, yes. We need
Yeah.
to hear yes, I
Yeah.
agree.
This is ongoing for
Yes.
a lot of women.
Yes.
Definitely.
Thank you.
Thank you.
Don't jump off, okay? Slam the Gavel is a podcast to help the public understand what really goes on in these courtrooms. I'm your host, Marianne Petrie. You can find me on Spotify, YouTube, Apple iTunes, iHeartRadio, Google, and other platforms I don't know about. Again, feel free to buy me a coffee to help keep this podcast going. I totally thank you, Katherine and Carol Moore, for coming out and sharing all of this valuable information with everyone. Thank you so very much.
Thank you.
Thank you.